considers the potential benefits of a code of ethics for the nation's highest court during a conversation with law students and faculty at the University of Minnesota. Her comments come in the wake of news stories detailing ethical concerns among some of the court's justices.
Good afternoon, Justice Barrett. So delighted you're here.
I'm delighted to be here, Professor Stein. Thanks for having me.
And thank you for coming, especially in the first 2 weeks of the current term of the court that began the first Monday in October. How's it going this year?
It's good so far. We're 6 arguments in, so we're on a 2-week in between our sessions. So we finished oral arguments last week, and now it will be 2 weeks of reading briefs to prepare for the next round.
Well, we're delighted that you're here for so many reasons. You grew up in New Orleans, the other end of the Mississippi.
I did.
And I think you said there's a family connection to the University of Minnesota. Can you tell us about that?
I did. Professor Stein did not know this when he invited me, so I don't think it was the reason he invited me. But my brother actually went to the U. So it's not my first time visiting campus. So he lived in a rental house in Dinkytown, so I went and visited him there when he was here. All right.
Well, I know that you know something about the university when you say the U. That means Minnesota. I'd like to start asking questions by asking a question about your undergraduate college. As the Dean McGovern said, you received your undergraduate degree from Rhodes College in Memphis, which is a superb school there. And I noted several years ago, Justice Abe Fortas graduated from that college, although it was then, I think, called the Memphis College of Law, if I'm not mistaken. Were you aware that a Supreme Court justice had graduated from your undergraduate school? And did you think at all about the Supreme Court at that time?
I didn't know that I wanted to be a lawyer at that time. So I had some vague awareness that Justice Fortas had once upon a time gone to Rhodes College. It was then Southwestern College, which he attended. Yeah. I was an English literature major in college, and I minored in French. And I thought a lot about going on to get a PhD in English and becoming an English professor. I also thought about teaching high school English. I also thought about going to law school, but it wasn't until I was a senior and I was really, down to decision-making time that I decided to go to law school.
And you made the decision to go to Notre Dame from where you graduated. As a graduate of Notre Dame Law School, you're the only current justice to graduate from a law school other than Harvard or Yale, and the only justice to graduate from a law school other than Harvard, Yale, or Columbia since Justice Sandra Day O'Connor joined the court from Stanford in 1981. Why do you think this is so, and do you think it's a good thing?
Let's see, I think it's a neutral thing, and I love all my colleagues and would never criticize their alma maters. It's true that it has been like that of late, but it hasn't always been that way. For example, I was thinking about it, I was reading some books over the summer, and it's striking to me that when Justice Frankfurter was on the court, renowned justice, as the law students in the audience know, he had been a professor at Harvard, but he served simultaneously with Justice Jackson, who didn't get a law degree. Justice Jackson learned law at a time when you could study law by being an apprentice. And simultaneously, Hugo Black was on the court, and he'd gone to the University of Alabama Law School. So it's true that recently the court has been, populated more with those who have gone to Ivy League law schools. But it hasn't always been the case, and I don't think it always needs to be the case, right? I think University of Minnesota and Notre Dame, and there are plenty of places that produce excellent lawyers, and they should not be overlooked.
Well, in addition to the fact that most of the justices graduated from the same Ivy League schools, not all, but most of them, most of the justices have the same professional background as a Court of Appeals judge. I think Justice Kagan may be the only one that wasn't a Court of Appeals judge before going on the court. I think she was nominated for one and not confirmed along the way. So do you think the court would benefit from more diversity in either geographic backgrounds? Most of the justices come from courts of appeal on the East Coast. So would greater geographic diversity and more professional experience, such as legislative experience, be a benefit to the court? I think Justice O'Connor was the last justice who'd served in the legislature before going on the court.
I think that's right. Justice O'Connor served in the Arizona State Legislature, and it may well have been her experience as a state legislature that made her particularly committed to federalism, which is, the balance for those non-lawyers in the room, which is, you could loosely say states' rights, but it's the independence of states in our federal system in which states that still...
Please quiet down and allow the lecture to continue. Demonstrations and disruptive behavior are not authorized inside the auditorium. Please quiet down and allow the lecture to continue. If the disruptive behavior does not cease, we will be compelled to invoke Minnesota statutes and disruptive parties will be required to vacate the room. Cue the slide, please. It is ordered that this disruptive behavior cease. The university revokes any claim of right of individuals to continue to disrupt this event. All those who fail to comply will be in violation of Minnesota Statute 624.72, Subdivision 3, interference with the use of public property, and Minnesota Statute 609.605, trespass, and will be placed under arrest by the university police. All disruptive parties are asked to vacate the room or be subject to arrest.
Well, let's resume our conversation. Justice Barrett, we really are Minnesota nice. And we don't treat other people like that very often at all. So we're so delighted you're here. You taught at Notre Dame for 15 years, and you taught a constitutional law course. Now that you've been on the court for 3 years, is the court what you thought it was when you taught it, or how would you teach that course differently now with your experience?
I think the court is what I thought it was when I taught it, and I think I would teach the class the same way when it comes to the substance, because the cases are what the cases are, and the role of the court, is what it is. But in thinking about what I know now that I didn't know then, and that I don't think I was a law clerk at the court to Justice Scalia, but I don't think I fully appreciated this even as a law clerk, the way that opinions are written. I mean, as an academic, as a professor, as a law student, and I'm sure the law students in the room sometimes feel this way, it can be frustrating when a Supreme Court opinion doesn't answer all the questions, or when it feels like some issues are glossed over. You think, what about this? What about that? And it is challenging to write on a multi-member court. So if you look at opinions and you read them very carefully, and you remember that the author of the opinion, when I write an opinion, I'm not speaking only for myself or only in my own voice. I'm writing for everyone else who has joined the majority. And that means that I have to find a way to thread the needle so that what I say is something that every one of my colleagues that's in the majority can agree to. And so sometimes that means glossing over some things where maybe people don't agree, or maybe people just aren't ready to take a position on something. And then we also, I sometimes see, law professors criticizing an opinion and saying, well, the court left this issue open, it didn't decide it. But it's not that we didn't know about it. I mean, that's usually a very deliberate choice because we want to be very careful not to answer too many questions in cases where those issues haven't been front and center and they haven't been fully briefed and we haven't had the benefit of a lot of opinions from the lower courts. So I think I would pay a lot more attention now, and I encourage you who are law students to do that, and thinking about why was an opinion written the way it was written, or why are some things missing that I think ought to be there. And I think appreciating that and the challenges of writing in that situation for a larger, I mean, even larger than when I was on the Court of Appeals, where I would be writing for one or two other colleagues. So I think that's the thing I've grown to appreciate the most, that I would approach differently in the classroom.
The court now has 4 women justices serving for the first time in its history. And you perhaps more often align with some of the conservative justices, and Justice Sotomayor and Kagan and Jackson often join with other liberal justices, although it's certainly not true in many, many cases. But are there occasions when the 4 women justices get together for any purpose well, get together for any reason, just to sort of celebrate the fact there's 4 now?
Well, let's see. I would say I am so delighted to have Justice Jackson as my new colleague. I would say that the women don't, I think ideologically, well, I'll start by saying this, Professor Stein. My very first dissent in my first term on the court was in a 6-3 case. But it was not the 6-3 that you might be expecting when you open newspapers. It was the 6 men, and I was writing the dissent for Justice Kagan, Justice Sotomayor, and me. So it is certainly not always the case, that women are on different sides. And actually, last term, I think it's the case that there were only 5 decisions in which the 3 other women, Justices Kagan, Sotomayor, and Jackson, were in dissent. So that's only 5 of, where they were the 3 together, that was only 5 of, say, the 57 or so cases that we heard. So there are all kinds of other lineups all the time, and I find myself, in a grouping that includes, say, Justice Kagan or Justice Sotomayor or Justice Jackson. So I wouldn't want to leave the impression that I'm never, voting alongside them. I was very excited when Justice Sotomayor assigned me that dissent, and I got to speak for them. I don't think that my perspective, or that anybody's perspective, is different just by virtue of being a woman, because I think we bring, to the law our methodological and jurisprudential commitments that are independent, of our sex. But I think it's delightful to have the companionship of them on the court. And it was a tradition on the court is that the formerly most junior justice, who is me, throws a welcome party for the new junior justice, who is Justice Jackson. So I got to do that. We did it last January, and it's just for the justices and their spouses, and retired justices and their spouses join as well. So I got to pick her favorite foods, and she picked her favorite entertainment. I did some sleuthing and found out she really loves Hamilton, so I found someone who sings on Broadway and came and serenaded her with some songs. So it's really delightful to have people on the court who I consider friends.
That's quite a welcome you get with the singers.
Well, for me, Justice Kavanaugh, as you know, I'm from New Orleans, so for me, Justice Kavanaugh and his wife Ashley, when they threw the party, they found some New Orleans singers to sing some jazz music, including a second line.
I wanted to ask you about one difference between you and the other women justices on the court, is that you may be the first mother with minor children to serve on the court. Indeed, you're a justice and a mother with several children in school. So how do you manage your work as a justice and the challenge of parenting school-age children?
Let's see, I think that my days and the struggle of balancing being a mom and having children in school and sports and school activities are probably no different than most working moms. It's the same struggle of balancing it all and fitting it in all the hours in a day that I had when I was a law professor and when I was on the Court of Appeals. So I think in that respect, my challenges are no different than the challenges of all working moms. I think the juxtaposition can be funny. I have 4 children who are still in high school or grade school. So in the mornings, we're getting them out of the door to school, and our youngest son is 11 and he has Down syndrome, and his bus picks him up last. The other kids are already gone. And he really enjoys music, so we're packing his backpack and I'll be packing my briefcase, and he chooses the songs. And so there was one day last term when Benjamin had been choosing some music, including, it's not so much, the opera classic, Who Let the Dogs Out? And I get to the court, and in the court, as you're walking in the hallways in the basement area, have portraits of all the justices who have served before, and they're very dignified looking. And all along in my brain, don't listen to that song if you don't want it to be in your mind all day long. I'm walking down looking at these dignified men and Who Let the Dogs Out on the... So I think there's a juxtaposition. I leave work and then I'll wind up at a volleyball game with a bunch of the other moms. Or, one day last week I was serving hot lunch at my kids' school as a parent volunteer. But I think all of those things are things that in my current position in particular I really appreciate, because they're very grounding and they keep me very much rooted in real life with, regular people, like the kinds of moms I've been sitting at, the sidelines of soccer games with my whole, mothering career, so.
Well, good for you.
Yeah.
Following graduation from Notre Dame, you clerked, as you mentioned, for Judge Silberman on the Court of Appeals for the D.C. Circuit and for Justice Scalia on the Supreme Court. And you've expressed great respect for both of them. Particularly, you've talked about Justice Scalia. And I think after your appointment to the court, you were quoted as saying Justice Scalia's judicial philosophy was also your judicial philosophy. Is that still true, and how would you describe that philosophy?
So Justice Scalia was very well known for his commitment to both originalism and constitutional interpretation, and textualism in the interpretation of statutes. And I would say that you could boil both of those judicial philosophies down to the proposition that the text is the law and the text controls. And I share that philosophy, and I share that commitment. So I think there would be very little difference between us if you asked about the central role of the judge, to adhere to the text when the text has a clear answer, and to not impose one's own views on the law, to respect the law. We certainly have some differences in style. For example, he's a fantastic writer, was very well known for being a fantastic writer. And he was, he could be a lot, like I would say, when you're at a restaurant and you're looking at the menu and it's trying to tell you how spicy things are, and it might have like 3 jalapenos next to one, and then I'm more of the 1 jalapeno judge than the 3, so I keep the heat. I tend to prefer the heat to be a little bit lower, say in dissents or in interchanges back and forth, but that made his a lot more entertaining to read.
Yeah, right. Well, I suppose coming from a Southern Italian background, he put more peppers on the...
More fire, yes,
yeah,
more fire.
Sure. Justice Scalia participated in a conversation as part of this series in this very auditorium, tragically only a few months before his death. Could you talk a little bit about started talking about Justice Scalia just now. Could you talk about your relationship through the years, both as a clerk and then the years since you were a clerk?
Yes, Justice Scalia was a great role model for a young lawyer. I mean, he was very funny, so being his clerk involved hearing lots of funny stories, being regaled with stories. I recall a couple times hearing him singing opera in his office. from the outside clerk's office. But he was very committed. My co-clerks and I were talking about this recently, actually. We were asking each other what we thought was the most important piece of advice that the justice gave us, and he said, always make it a virtually immovable commitment to be home to have dinner with your family, because that's the most important thing, no matter how much you have to work later at night to do it. And I think, and we all remembered being very struck by that. And so I think even apart from everything he taught me about the law and how to think about the law and how to think about being a judge, I think he was an example just as much about being a person, being a person who, he was great at maintaining friendships with, people who had views who were very different from his own. I mean, his friendship with Justice Ginsburg was, a great example of that. But he was full of life, and he didn't hold back. And he liked to say, I attack ideas, not people. And that if you can't tell the difference between the two as a judge, you're in the wrong line of work. And so as fiery as he might have been because of his Italian background, he was very good at maintaining relationships and being committed to his family, and I think that was a very important example to me. So I didn't just learn law.
Well, that was a remarkable friendship between Justice Scalia and Justice Ginsburg, and she told stories of the two of them, and was very proud that an opera had been written about their friendship. I think it's called Scalia Ginsburg, and she explains since he was a senior justice, his name came first. But I've never seen the opera. Have you?
I actually have not seen the opera either.
Apparently, in the opera, he was imprisoned for excessive dissenting, and then somehow she rescues him coming through a glass ceiling, which he breaks. So they had a wonderful relationship between the two of them. When you joined the court in 2020, I wanted to ask you, were there some justices that reached out and were even more welcoming than others? You mentioned Justice Kavanaugh put on this New Orleans dinner for you. How was it joining the court?
So I joined the court during COVID, so the pandemic was still raging and people hadn't fully come back to work. Although when I was sworn in, I mean, I wouldn't say that any one of my colleagues was more welcoming than another, because they were all equally welcoming and wonderful. So when I was sworn in by the Chief Justice, Justice Breyer was still remote. He was still in Boston, and so he couldn't, it was a problem for him because he couldn't travel without, greater exposure. But those who were in Washington came to the court for the swearing in and sat. We just did it in a big conference room, and everyone had masks on and spread out, socially distanced in the conference room. Everybody was there. Everybody was warm. One of the things that meant a lot to me in that beginning was it was right around Halloween, and Justice Sotomayor came to my office, and Jesse, my husband, had come for the swearing in, and our children were back in South Bend, and he was going to be leaving in an hour or two to go back to South Bend to hold down the fort while I was commuting back and forth from Washington. And Justice Sotomayor came in, and she had made bags of Halloween candy for each one of my children for Jesse to take back to them. I had no staff. I went in, I had no staff, no law clerks, no office supplies or anything that day. You can't really hire a staff before you're confirmed, and so it leaves you scrambling. And I had my first oral arguments in just a few days, and I didn't even know how to get into the computer system. And Justice Gorsuch found out, and so he just dispatched his assistants to come over, and they answered my phones, and they stocked me up with office supplies, and it was just thing after thing. I was living by myself 2 weeks of a month in Washington in the house that I was renting, and I had dinner invitations from my colleagues and lunch invitations, and they did everything in their power to make me feel welcome at what was a difficult time. I mean, they had just lost a beloved colleague, and Justice Ginsburg had just passed away. Everyone was under the stress of COVID, and everyone went above and beyond to really make me feel welcome.
That sort of leads into the next question I was going to ask you. There have been some extremely sharp differences in cases the last couple of years between the majority and the dissent. And have those sharp differences affected the relationship between the justices at all? Does it continue to be a place where justices embrace one another?
It is. And I'll go back to that saying that I just repeated from Justice Scalia, I attack ideas, not people. I think that is what opinions are. You know, the fire gets put on the page, but it is not expressed in interpersonal relationships. I mean, you have, the court decides issues of great importance. There are, you know, lawyers on the court who are very smart, who are passionate about what they're doing. Convinced, because everyone gives a great deal of study and time and attention. You spend months with briefs and listening to oral argument when you first participate in it, you know, listening again to oral argument, talking with your clerks, talking with colleagues. And at the end of that process, you are sure that your answer is right. But you know, when you're on a multi-member court, there will be others who see it differently. In many cases, especially some of the ones that are the most difficult, and some of the ones that really press on jurisprudential divides, say between, you know, originalism or textualism and a theory that leaves more play in the joints of the text. And so those are very difficult cases in which jurisprudential disagreements can be sharp, but it really does stay to the page. And I think, I think that's one reason why some of the things that, you know, we were saying at the beginning about this lecture are important. I think part of that is time spent. So we are in the building with each other. Justices have lunch every day that we have oral argument and every day after conference. So just coming off of these last 2 weeks when we are in session, you know, that's 8 lunches. There was one lunch I couldn't go to because I had a child care issue. But we eat together, we spend time together, and I think when you know people as people, even, it's not because I'm going to say change Justice Kagan's mind when we're talking about something. I'm not friends or friendly with her or show affection or warmth because I think in a means-ends related way, I think I'm going to try to lure her to my side and get my vote. It's because I honestly enjoy her as a person, and she's very smart and she's very funny, and I enjoy spending time with her. And I think when you have relationships with people and when you spend time with people, you know, it's easy to see them as people and not just embodiments of ideas that you disagree with.
When you talk about Justice Kagan being very funny, she was a participant in this conversation in the past, and she is hilarious.
She is hilarious.
And your Justice Scalia was certainly hilarious. Who's the funniest member of the Supreme Court right now?
So this is kind of like when someone asks me, like, who is your favorite child? And this is being recorded, so whatever I say. I have many funny colleagues.
Okay, very diplomatic. Let me turn to a more serious question. The court has been criticized for not having a code of conduct applying to Supreme Court justices, and Chief Justice Roberts has been quoted as saying the court is working on it, and various justices have made comments that there's not yet a consensus about such a code of conduct. The Senate has now passed a code of conduct applicable to justices. Let me ask you, do you favor a code of conduct for Supreme Court justices, and what benefits do you see that would provide?
I think it would be a good idea for us to do it, particularly so that we can communicate to the public exactly what it is that we're doing in a clearer way than perhaps we have been able to do so far. I will say this, there is no lack of consensus among the justices. There's unanimity among all 9 justices that we should and do hold ourselves to the highest standards, highest ethical standards possible. So, I mean, I think what we are thinking about, you know, in thinking about what I think about in a code of conduct, is how best to express what it is that we are already doing. You know, and we already abide by the statutes. There are a number of statutes that govern all judges, including justices. We all file our financial disclosure forms, for example, or like gift regulations. Those are statutory requirements. And then I personally, and this is true of my colleagues as well, still follow the same rules that applied to me when I was a Court of Appeals judge, the canons of conduct. There are some differences that apply to the court just by virtue of its position in the hierarchy of the judiciary. And I think, you know, we spend, our day job is, you know, reading statutes and seeing if Congress anticipated everything or communicated everything clearly. And so, you know, I think we want to do a good job at that. So.
Do you think it will take much longer to come to an agreement about what a code might be, or what do you foresee looking ahead?
Well, let's see. I think that's something that I can't really speak for the court about or make any sort of guess about that. I would just say that one thing I would want all of you all to know is that all 9 justices are very committed to the highest standards of ethical conduct. All 9 justices, I mean, and we're in agreement about what to do, and that we want to continue to follow the highest ethical standards. So any disagreement is nothing to do with either of those principles.
Well, let me turn to another hot button issue.
Oh, well, thank you, Professor Stein.
We can't all be fun and games. The court has been criticized for overturning long-standing precedent in some major decisions in the past 2 terms. And without getting into the issues in those cases, could you comment on the weight you think should be given or that you give to long-standing precedent? How do you weigh that in deciding how to decide a case?
Sure. Well, I think before I answer the latter part, I do want to just quibble with your premise, because the court, actually the Roberts Court, including my time on it, is at a low. When you look at historically how many precedents are overruled a term, we're at about 1, and historically it's at about more 2 or 3. And in the last 2 terms, so there was Dobbs, and I think a lot of things probably get filtered through that lens, as it seems like, you know, the court has overturned a lot of precedents. But the Library of Congress does a tracker to show how many, there's a table showing how many precedents that the court has overruled, and it's only been 2. A case, Edwards versus Vinoy, which partially overruled Teague versus Lane, and Dobbs. So I don't think it's empirically true to say that we've overturned a lot of precedent, but we have overturned precedent. And every court does, you know, the court does over time, you know, when you look back through time, because the doctrine of stare decisis, which is the doctrine that says the presumption is that precedent stays, has never said precedent is absolute, nor could it, nor would anyone want it to, because if precedent were incapable of being overturned, we wouldn't have Brown versus the Board of Education, because Plessy would still be the law. You know, Lawrence versus Texas, which recognized a right to same-sex sexual intimacy, overruled precedent. Obergefell versus Hodges, which was a case that recognized the right to same-sex marriage, overruled precedent as well, holding to the contrary. So there have been many cases over time that have overturned precedent. And I think the doctrine of stare decisis is how I think about it when I think about weighing it. So there's precedent about precedent, as it were. So over time, the Supreme Court has developed a doctrine that itself contains guidelines that tells the court when it's time for a precedent to be overruled. And those considerations are the ones that I myself consider in deciding when it's time for a precedent to be overruled. And there are things like, you know, first of all, is it right or is it wrong? Because it obviously only becomes a live question if the prior case was wrong. And then if it was wrongly decided, you ask about what the effects of that error are having on the law today. Would correcting the error upset reliance interests? Has that error distorted other areas of the law, or is it becoming difficult for courts to apply? Those are the kinds of considerations. And so it's a balancing act where you don't want to leave errors uncorrected unless there are very good reasons to do it, for doing so. And oftentimes there are really good reasons for letting sleeping dogs lie. But it's a challenge because, remember, the Constitution is the law ratified by the people. And so if a court, especially if it's a constitutional precedent, if the court has gotten it wrong and there's a constitutional case that has interpreted the Constitution incorrectly, there's a cost to that as well. There's a cost to democratic choice because people are either hindered from doing things they might want to do, or the state is permitted from doing things the state might want to do, for example. So sometimes it's important to overrule precedent, and because it can be particularly costly in the constitutional context, and it's particularly difficult to remedy errors because if the court doesn't fix it, the only way to remedy an error is constitutional amendment, which is a difficult process. So the court has always given constitutional precedents less stare decisis weight than, say, statutory precedents, which are given super strong stare decisis effect, is what some of the cases say, because those are more easily corrected by Congress through legislative action. So overruling precedent is not something to be done lightly, but the court's own guidelines that it's always has followed for centuries recognize that there are times when it is the court's duty to do so.
Well, your list of cases that did overturn precedent and are widely hailed is, I think, an impressive list where the court has gone in the past. Could I ask you, Justice Barrett, what is your view of substantive due process?
So substantive due process, for those non-lawyers in the room, is a doctrine that's located in the 14th Amendment. And the 14th Amendment's due process clause says that no person shall be deprived of life, liberty, or property without due process of law. So as written, that language sounds procedural. It sounds like it's guaranteeing that no one is going to, for example, confiscate your property without giving you due process, or relevant to students at a public college, that's run by the state of Minnesota, that you have rights vis-a-vis the state, vis-a-vis the university, that due process would protect procedurally. But in addition to those procedural guarantees, that clause has come to embody what's known as substantive due process, which is a series of substantive guarantees as well. So, for example, the right of parents to direct the upbringing of their children is one of the first of this category that the court recognized as located in the substantive due process, as a substantive due process right located in the due process clause. Substantive due process is a controversial doctrine because the due process clause itself, as I said, some say, hey, that's procedural language, so why is anyone locating substantive rights in there to begin with? And because those rights are not express, but are rather ones that the court locates or describes as implicit in the text, you combine two very difficult factors, right? The court is identifying rights that the text does not make explicit, and then some of the rights that the court has identified as located in the due process clause are the particularly hot-button ones. So the due process clause was the source of that is the source of, say, the right to use contraception, which the court recognized in Griswold versus Connecticut. It was the due process clause in which the right to abortion was housed. So the court has identified some rights as implicit in the concept of ordered liberty and located in the due process clause, but it said that others, for example, that the right to die is not one of those rights that is inherent in the due process clause and therefore constitutionally protected. Now, it's tricky business to identify rights that the people, in ratifying our foundational document, the Constitution, have not themselves identified. And so the court, as a matter, again, of the precedent of stare decisis, has tried to ensure that the court doesn't get too far out of its lane by saying that the only kinds of rights that can fairly be described as being located in the Due Process Clause are those that are protected by long-standing and deeply rooted traditions, because that prevents the court from just saying, you know, we think that in a good and moral and just society, this is a right that people should have. It should be the people of the United States, through their state constitutions and through the federal constitutions, who themselves decide in a good and right and moral, just society, these are the individual rights that people should have. And so the bar for recognizing rights in the substantive due process doctrine located in the Due Process Clause, that bar should be high, and our precedent sets it high, so that the court doesn't act as a constitution maker rather than a constitution interpreter.
Well, that's a good statement of your position. Let me turn to another area. The court has been deciding fewer cases in recent years. Some commentators have called that the court's shrinking docket. And not too many years ago, when was doing work in this area, the court was deciding 100 to 150 cases a year. And in recent years, that number has dropped to about 75 cases a year. And you mentioned that earlier, I think 57. I think last year the court took 57 opinions, one of the lowest. I'm not sure it was the lowest.
Don't quote me on 57. I might be off by one or two, but it was right around there.
Yeah. So why is the court taking fewer cases? And would you personally favor a docket that had more cases on it, where justice could agree to, I guess you need to get 4 justices to take a case, but would that be better, if you think, if the court took more cases each year?
Let's see. Well, I will say that the court's merits docket, and the merits docket, by that I mean the cases in which the court hears on the merits and then makes a decision on the merits, is smaller. So let's say around 57 last year. But the number of cert petitions that are filed is also smaller. So the cert petitions, petitions for certiorari, are the petitions that litigants file when they're asking the court to hear a case. And in the past, they may have approached, as many as 5,500 to 6,000. Right now, we're closer to 4,000, so the numbers are down. I think that might have, I'm not exactly sure why. There are various theories. Right now, I think we might be seeing some of the after effects of COVID, because during the pandemic, district courts weren't conducting trials, and so therefore those cases, there weren't cases that were then appealed to the Court of Appeals that are now making it up to us. I think everything slowed down, and we're at the end of the line, so I think we're seeing a little bit of that lag. But even before COVID, it was dropping a little bit. The Chief Justice has said, we've talked about this, his theory, and I think he actually might have floated this theory with you at this very lecture, is that electronic legal databases like Westlaw might be reducing the number of circuit splits that we have. And I'll explain what a circuit split is. Circuit splits are when the courts of appeals across the country take the same legal issue and resolve it differently. And that's one of the classic cases in which the Supreme Court will step in, because we are at the top of the judicial hierarchy. If there are disagreements, we can resolve them to make the law uniform throughout the country. So if state Supreme Courts are disagreeing with one another, or if state Supreme Courts are disagreeing with the federal courts of appeals, you don't want to have different law applicable in, say, California than Oklahoma, or in Minnesota than in Louisiana. So the court will step in and resolve those splits. That's probably the most common situation in which we step in and get involved, and I think there are fewer splits than there used to be. So one thing that we always say, and that some people are surprised to hear, is that we don't take cases just to correct errors, just error correction. We have not historically done that, so the Supreme Court rules identify the factors that we apply in deciding whether to take a case. And so is there a circuit split, or is this an issue of national importance that really kind of demands the Supreme Court's intervention if an act of Congress has been held unconstitutional, if the federal government asks us to take a case, if state governments ask us to take a case? Those are all things that we take into account and that weigh heavily in favor of granting cert. And I will say that I think it, would be good probably to have more cases, but I don't think we're leaving cases on the table that I think that we should take. I mean, we're looking carefully through the petitions, but unless we were to change the traditional criteria, I don't see a lot of things that we're not taking that it would make sense for us to take.
Well, you've certainly been taking a lot of hot-button cases in the last few terms. You've taken cases that have had a lot of attention. Let me turn to oral argument. During COVID, the procedure involved in oral argument changed in some respects. If you could maybe talk about that, but more particularly, how has it changed oral argument going forward?
Sure. So in COVID, the court conducted oral arguments by audio. And to make it manageable, if you have 9 justices, if any of you have ever listened to a court argument or maybe attended one in person, you know that they can be a lot of jumping in and justices are asking questions, and it can be a very hot bench and it can be very active. And over audio, it could be very challenging for the advocates if they're just hearing disembodied voices cutting in over one another, trying to figure out how to respond. So to make that manageable, the court had a more routinized regime in place where the justices, in order of seniority, would ask questions, and you had an uninterrupted block of time in which each justice had a couple minutes and could ask the advocates the questions, and then when that time was up, it went on to the next, and so on. And I was last because I was the junior justice at that point. It was actually, I thought for me, as a brand new justice, I appreciated that system because it didn't put me in the position of having to talk over my senior colleagues right when I first started and being aggressive just to get my questions answered. So I appreciated the opportunity to ask questions uninterrupted and without having to potentially interrupt someone else. When we went back to the bench, we had to decide, were we going to keep that system and keep going, just asking questions, one by one? Were we going to return to the old way, where it's more of a little bit more of a free-for-all, or do some combination? And so we chose to do a combination, and we have first Justice Thomas, as Senior Associate Justice, asks his questions, and then the floor is open. And the only rule really is, we're all supposed to be cognizant of our time, but the only rule really is that if 2 justices speak at the same time, the more senior justice gets the floor. So you're supposed to yield to the more senior justice. But other than that, it's just you get in and you ask your questions. But we do have a cleanup round at the end. Once the advocate's time is over, we do something that looks like what we did during COVID, and it goes down the line from the chief down to Justice Jackson, who's now the most junior, and you get to ask your questions for a few minutes. And I think it takes some of the pressure off the open floor round, because you know that you will have a chance to have your question asked, and you don't have to feel like you have to be really aggressive about getting your question in. Although by the same token, it's not good practice to save all of your questions for the cleanup round, because then really prolongs argument. So we try not to do that and to be sensitive to the time. But we wound up with a blend.
Well, when we think of Supreme Court cases, we, of course, think of the oral argument, and certainly the media covers oral argument and the questions that are asked and that sort of thing. But let me ask you, what is the benefit of oral argument? Are you ever persuaded by an argument by counsel to change the opinion you had after reading the briefs?
I am. I think it's a myth that oral argument doesn't change minds. I do my homework before oral argument, so I go into argument with a sense, and that sense might be stronger or weaker, depending on the issue and, whether it's something that I've already written about or thought about before. Some areas of the law, and as a new justice, I'm still seeing some areas of the law in which I haven't decided a lot of cases in that line of cases, whereas if you've been on the court as long as, say, the Chief Justice, you've written some of the key opinions in the area in which, the new case arises. But in any event, no, oral argument, it can change my mind. It has changed my mind on the bottom line before. It also has an effect on how opinions are written. And so those of you lawyers and law students in the room who might want to be appellate advocates one day, one thing that's very effective, and justices, you'll often hear at argument, well, how would you write the opinion? Or, just at oral argument last week, Justice Thomas asked a question that said to counsel, just finish this sentence. This is unconstitutional because. Like, can you articulate the line that could then be the holding in a case? And so an advocate's answer to that might change someone's mind. It might change how an opinion is written. And so I think it's important. Oral argument is important. It can affect the scope of the opinion. You realize that impracticalities in the argument, that sometimes you realize, wow, that argument was just as unmanageable as it seemed going in. Or you say, like, hey, no, actually, there is a way to handle this if you're trying to walk a tightrope between competing lines of precedent, for example. The lawyer might say, no, you really can do this, and you really can write this in a way that's not going to mess either area up. So no, oral argument matters.
Let me turn to another part of your career. You were a longtime law school professor, and let me ask you some questions about legal education. What's your opinion of legal education today? Do you think we're doing a good job training our students for the various roles they would take, or what changes would you like to see?
I think broadly speaking, so I think law schools do a good job. And obviously the law school with which I'm most familiar is Notre Dame, because it's the law school at which I taught and that I attended. I think one thing that's really important in legal education, and something I thought about as a law professor, and it bears on some of the things we were discussing earlier. As a law professor, so for example, I taught a seminar in statutory interpretation, which is, the theory and art of how to interpret statutes. So I'm a textualist, which means, I follow an approach to statutory interpretation which would aim to identify the statute's best meaning, its ordinary meaning, and then follow that, even if that ordinary meaning might seem in tension with the purposes of the law, or that I think I could make it make more sense if I didn't quite enforce what it said to this point. I think Congress actually would prefer if in a situation like this I decided the case this way, even though it's in tension with the text. In a nutshell, for the non-lawyers, that would be textualism. But there are other schools of thought. So for example, Justice Breyer was a very eloquent advocate of a more pragmatic interpretation, approach to interpretation, which would say, well, the text matters and we consider it, but there are some times in which we shouldn't, be slaves to it, and we should think about the pragmatic consequences and the pragmatic ends. There are approaches like Justice Breyer's, which might be inclined to give more weight to, say, legislative history, whereas my approach and approaches like textualism would minimize that. So I bring this up to say that when I taught statutory interpretation, I tried very hard to keep my own views out of it. And when I was a law professor, that was a lot easier because now my views are more obvious. When I was a law professor, I tried to keep my own views out of it. I really wanted them to learn both sides. And if people in the class were making arguments, frankly, arguments that I agreed with, and I didn't feel like people on the other side were making the other arguments, I would step in to be devil's advocate and make the other side. I think that legal education, if it ever slips away from teaching students how to see both sides, how to see the best argument for both sides, then I think in that point, legal education would be doing students a disservice. And as I would tell my students in statutory interpretation, you might leave this class thinking, for example, that legislative history is a useless tool and a dangerous tool and judges shouldn't use it. But I said, when you go into practice, you better use it if you think, you're representing a client. So you put it in your briefs if you think it's going to persuade a judge. Because you have to be an effective lawyer, you have to understand how to use all the arguments, and you're not going to be arguing in front of judges who necessarily see things the same way that you as the lawyer do. And so I think it's really important for law schools to do that, to equip students to be able to see both sides, to debate both sides, and to use all of those tools.
You've talked about what the law schools should do. What advice would you have for law students who are in the audience today?
So I think for law students, I would say, take advantage of all of your opportunities to learn about lots of things and to challenge yourself. Expose yourself to ideas that you might not think you agree with, and you might not wind up you may not agree with them at the end of the day either. But law, I mean, how many people who decide to go to law school were told at one point in their childhood, like, oh, well, you like to argue, so you're probably going to be a lawyer. It's true that lawyers wind up arguing, and that's true whether you wind up being a litigator or whether you wind up being a transactional lawyer and you're having to negotiate deals. You need to learn how to see both sides, and you need to learn how to argue, and you need to learn how to be able to do it collegially and civilly, because that's what lawyers do, and that's how you produce results for your client. That's also how you become good citizens. That's how you become leading members of the bar. That's how you contribute to your community. So I would say soak up all of the opportunities that you can to take classes that challenge you, to hear ideas that challenge you, and learn how to debate and argue in ways that are respectful and will prepare you for when you step into the courtroom or the deal room and have to do that same thing.
Well, I'm going to turn to questions from law students in just a minute, but I did want to ask you a question first. Are you enjoying yourself on the Supreme Court? What do you enjoy most about the experience?
The work is important, obviously, and the work is, it's similar in substance to what I did when I was on the Seventh Circuit, because you're deciding cases, resolving disputes, reading briefs, and thinking about the law, writing about the law. And so the substance of the work is the same, and it's a privilege and an honor to serve the country and do that work in ways that really matter and that affect it. It's a weighty responsibility, and I feel the weight of that, knowing that what I do, I always want to be very well prepared and do my best and think hard and discharge all of the duties of my office consistently with my oath and in the most to the best of my abilities, in the most responsible way possible. And that's different than being a law professor, where you're not exercising the power of government. And so I always wanted to do my best and do my best by my students when I was a law professor, but the weight of the job wasn't something that kept me up at night because of the weight of the job. And so I feel a grave responsibility, and so while it is a privilege and it's obviously interesting, and I'm amazed that I get to work with the colleagues that I have who are smart and warm and lovely, and I'm walking into this building, I was amazed walking into that building when I was a law clerk, and I'm amazed now walking into that building as a justice. The court serves such an important function in our society. So I would say enjoying myself isn't quite the right word that I would use, but it's a privilege to serve, and I have no regrets about undertaking the service, and I'm fully conscious that everything I'm doing is very important for the people of America, and those are the people for whom I work.
Very well said. Well, I'm going to turn to questions from students. Now, some might touch on areas we've already talked about, if you have anything more to say about it. The first one is, the rapid advance of technology often presents new challenges for the legal system. How do you approach cases where the law hasn't yet caught up to technological realities?
So I think technology is one of the challenges, and I'll say just a couple things about that because I don't want to take up all the time so we don't get to all the questions. You know, last term the court heard cases involving Twitter and Google and the intersection of an anti-terrorism statute and social media algorithms. And those are challenging cases because technology changes so rapidly, right? And you're thinking about these issues. We are limited in what we know. I think that was the case in which Justice Kagan said something on the bench about, like, you know, we're not the 9 greatest experts on the internet. Congress also, I mean, statutes can be difficult because statutes become quickly outdated. We have some statutes that were written directed at cable TV, but now they're having to apply to the internet age and to internet services and streaming services. So I think that is a very, very difficult area, and I think that's one of those areas when I said that when we decide whether to grant certiorari and hear a case, I think that's an area in which there's need for caution and prudence. Sometimes we can't avoid stepping in because there's a conflict and we just have to step in and resolve it. But I think that's an area in which, you know, we're aware of that, and that personally I think letting some time for technology to develop and for lower courts to grapple with those issues benefits the court. It's not something you want to jump in and make a mistake in when technology changes.
Here's a second question. In your opinion, what is the role of dissents in shaping legal interpretation, and how do you view dissents in your role?
So people write dissents for different reasons, and I've seen different people express different reasons for it. Justice Breyer, he said once in a speech that he gave that he writes the dissent for himself because he wants to express his view, but he also kind of has that last hope that he'll convince his colleagues because, of course, you know, he was right. And he said, and then he would tell his wife, they didn't join me. You know, you have to explain yourself. You know, Justice Scalia used to say that he wrote his dissents for the law school case books because if he could write them really well, then the law students would read them. You know, he could influence the law students, and maybe one day those dissents could become majorities. And Justice Ginsburg actually said something similar. You write dissents hoping that one day they may become majority opinions. I think of dissents as, you know, you need to show what both sides of the argument were, and if you saw the case differently, you have to explain why. And sure, there are some cases in which you hope that a dissent might become a majority, but in many ways, dissents leave less room for discretion than other separate writings like concurrences. I think those are ones in which maybe you have an even still greater judgment call to make about when you write in an effort to point to issues that need to be addressed or that should be addressed or to shape the law.
Thank you. Now here's another student question. In a world with many diverse viewpoints, particularly with statutory and constitutional interpretation, how do you balance the practice of originalist and textualist ideals with the increasing abundance of definitions of text? As a textualist, I guess the issue is there too much
Is there
text?
too much text because there are too many statutes?
Yeah, well, world of more viewpoints, I guess.
Oh, more viewpoints? Mm-hmm. So I'm not sure I totally follow the question, but I'll take a stab. So one thing that question might be getting at is that a textualist tries to interpret language as an ordinary reader of the language would. And so it could be that one thing that question's getting at is who's the ordinary reader? And do we have, like, in torts, for you law students, you have the mythical reasonable man, and you judge everything through the eyes of that reasonable man. So a textualist maybe judges everything the eyes of that reasonable reader. So it could be, that question might be getting at, when you have so many different ways of looking at the world and hearing language and looking at text, how can you possibly identify who that ordinary speaker of the language is? And I would say that it can be difficult, honestly, to figure out who's the target audience for the statute, so who is that reasonable reader. But you narrow it down in textualism, and all 9 justices treat the text as controlling. There are differences in how you would get to it, but I don't want to give the impression that, you know, I'm the only one for whom the text is relevant. I mean, text is important to everyone. You are reading the text as an informed observer who's familiar with all of the circumstances and facts of that statute and that statutory language. So that does narrow it down to someone who is an informed observer and familiar with the statute and its context, and so that does help. But I do agree, you know, that it can be challenging in a world with many viewpoints to figure out who that mythical reasonable person or mythical ordinary user of language is.
This next question is interesting, particularly to go in another direction. What role does empathy play in your judicial decision-making process, especially when faced with cases that have profound personal and societal implications?
That's one of the very difficult things about judging, and it was something that I found difficult on the Court of Appeals and that I find difficult now. On the Court of Appeals, I felt it very acutely, I can recall, in several criminal cases. And on the Supreme Court in criminal cases too, but in many, many different cases. One of the challenges about being a judge generally, not just a justice on the Supreme Court, is the need, on the one hand, to follow the law, and I don't want, and nor should I think it would be a violation of my oath to let my emotions or my personal feelings dictate the outcome of a decision. By the same token, I don't ever want to lose sight of humanity and ever lose sight of the fact that our decisions have real-world consequences. So it was one practice that the court has is we deliver a bench statement where the author of majority opinion will announce the opinion on hand-down day, and you give a brief summary of the opinion. And we didn't do hand-downs during COVID, and when they first came back last term, and the very first time that I did a hand-down, it was in a case involving disability benefits for a veteran. And it was a 9-0 decision, but the court held that the rule that the veteran wanted, which would have given him access to disability benefits, we decided against the veteran, that it wasn't available. And when I went into the courtroom, it just so happened that the courtroom was packed with JAG lawyers and members of the armed forces who were there to be sworn into the Supreme Court bar, and they were all in uniform. And it was a very good reminder to me. I had to read my opinion, and I had to meet eyes with all of these members of the armed forces in a case in which the court was deciding against someone who had served our country. And I left the bench and I said, like, really? Like, you had to schedule the hand-down on this day? But I had to do that. I had to own it. You know, you can't just hide in the court and forget about the real-world impacts, however hard they are. I have a hard time, you know, with the death penalty. I have a hard time in these cases, but I think as a judge, it's important it's your head, not your heart, that has to make the decisions, but you should never lose sight of the fact your decisions affect real people, and you should never lose your heart.
Justice Barrett, the next one, what books or writers have influenced your legal writing style?
I don't know if I could pinpoint what writer influenced my style, but one thing that I will say is that the first research paper that I ever did in high school was on Ernest Hemingway, and I was very taken with his style. And Hemingway, as you know, he's a very spare writer, and he doesn't use a lot of adjectives, he doesn't use a lot of adverbs, and that's generally the way I write. I'm pretty spare, I try to be very linear, and when I was clerking for Judge Silberman on the DC Circuit right out of law school, he called me into his office one day and he said, "Amy, you're an excellent writer, but don't be afraid of the adverb." So I think my writing style, I am no judicial Hemingway. I don't claim that. I don't claim that. But I do tend towards despair, and I try to keep Judge Silberman's advice in the back of my mind.
Now, this is my question, not one of the students, but since we're talking about writing, who are you writing to when you write an opinion? Are you writing to the other justices? Are you writing to the general public? Are you writing to the parties to explain why you're deciding? Who's the audience for your opinion?
A little bit of everyone. I think it's important. I always tell people, and I suspect even lawyers don't, listen to this advice, that they should read the opinions. So I want opinions to be accessible. So I try to write in a way that is accessible as possible to someone in the public who's interested, but maybe not a lawyer, in reading an opinion. But the reality is that not all opinions lend themselves to that, because some do involve technical topics, technical language, and so I can't say, hey, I'm writing this in a way that my mom, who is not a lawyer, could necessarily pick this up and find it entertaining and followable. So I am always, though, writing for the lawyers and the parties and the bar. Because I'm a professor, I also have law students in my mind. I mean, I spent, 20 years. I'm still teaching. I'm still trying to teach at least once a year. I'm writing for my law students. I'm writing for the students that will have to read the opinions. I want them to be able to follow them and understand them.
Your answer that you wanted people like your mother to understand the opinion reminds me, I asked that same question of Chief Justice Roberts, and he said he was writing to his sisters. It was the same thing. He wanted to be sure his sisters would understand, who are not lawyers, but so it's another way of saying to the American public, understand the reasons for the decision. Another couple of questions here we have time for. This is from the students. Are there any historical Supreme Court decisions or justices that have particularly influenced your judicial philosophy or approach?
So obviously, because I saw so much of Justice Scalia in the year in his chambers, that I would have to say had the largest impact on my judicial philosophy. But I think when I think about the history of the court, and I think about, especially now that I'm there, justices who have set a course, I think, and so many people say Chief Justice John Marshall, but I'm going to say it for a different reason than Marbury versus Madison in judicial review. The theme has come up several times about collegiality and building consensus on the court, and he was really a master at that. When he joined the court, when he became chief, the justices weren't even all living in the same city. They would come and congregate, towards the end, like Washington, once that's where the court was housed. They didn't have a building, they didn't have chambers, and he had them stay in the same boarding house. So they would take their meals together and be together while they were there hearing cases. And that really had the effect of building camaraderie on the court. He instituted the practice of announcing an opinion for the court. Before John Marshall, opinions were announced seriatim, which means that each individual justice said how he, because it was all he's back in those days, how he saw the case. And I think as I have been a judge both on the Court of Appeals and the Supreme Court, I just see how important it is on multi-member appellate courts to be able to work towards consensus. And so I have that in my mind as something that's really influenced me.
Well, I think this will be the final question we'll ask of these wonderful, incidentally, thank you very much, students. These have been terrific questions that you wrote. In your opinion, how can the legal profession become a more inclusive place for people from historically underrepresented communities?
I think law schools should be doing everything that they can to make first-generation students, feel welcome and give them the help that they need. And the legal profession, too, that shouldn't end just in law school with mentoring and that kind of advice. The legal profession, and I encourage all of you who are law students, once you get into the bar, to give your time to mentoring young lawyers and young lawyers who are new to the profession, who may not come from families who had lawyers in them or who are from historically underrepresented communities. I think if this is the last question and this is my conclusion, I think I will say that I think for all of you, as you think about one another, whether you're looking at welcoming those from underrepresented communities into the school and in your profession, whether you're looking at people with whom you disagree, to really see one another as people. One thing that is striking about America that I would tell my con law students when I taught con law, we are a huge country. I mean, we have few rivals in the size of our population and our land mass. And we all are living together under this very large tent, and the Constitution is what unites us. And so we have to figure out a way to find our common ground and persuade one another and see one another's humanity, see the humanity of those with whom you are now sharing the legal profession and who you will continue to do so in the future. So you are the future of the legal profession, law students. So I entrust it to you, and I know that you will do that, and I thank you for the lovely reception that you've given me here today, and thank you for coming to hear me speak.
Thank you, Justice Barrett, very much.